Welcome back to Tipping Point. I'm your host, Kara McKinney. We have an important update about an ongoing court case we previously covered. The U.S. Supreme Court just dealt a huge blow to organized labor in a groundbreaking ruling, which allows private companies to sue labor union officials in court for permitting the destruction of company property during labor strikes. Glacier Northwest Incorporated, a ready-mix concrete delivery company based out of Seattle, Washington, filed a lawsuit in Washington State Court back in 2017, accusing affiliates of the International Brotherhood of Teamsters Local Union 174 of intentional property damage. It was back in August of 2017 when company truck drivers went on strike and abandoned their vehicles on company property while they were still full of wet concrete. The strike lasted about 1 week, but after the new collective bargaining agreement was made, those cement batches were dry and totally unusable, prompting the company to file a lawsuit for damage to the trucks. According to Glacier Northwest, this action caused chaos because company officials scrambled to dispose of the sabotage materials in a cost-effective and environmentally friendly manner. Despite the damages to both the company and to its customers, their case was dismissed, and the Washington State Supreme Court said the property damage is protected under the National Labor Relations Act of 1935. However, 8 of the 9 sitting U.S. Supreme Court justices, everyone except Justice Ketanji Brown Jackson, that is, argued union officials can be held legally responsible for any property damage done to private company property during labor contract negotiations. Now, ultimately, this is about equally and universally applying the law to all people, including to powerful union bosses who abuse their positions to bully private companies and to manipulate domestic elections. Labor union leaders enjoy a wide range of special privileges and advantages that don't extend to average citizens. However, as our next guest argues, it's time to address this glaring problem. Joining us now to discuss is Mark Mix, the president of the National Right to Work Legal Defense Foundation. Mark, thanks for being here tonight.
Good to be with you, Kara, and thanks for talking about this important case. It really was a major case, and basically what it said is the Supreme Court denied what Washington State wanted to do, the Washington State Supreme Court is, and that's give union officials dramatic new powers and new privileges to basically stop any type of litigation when it came to intentional property damage. The Supreme Court sent the case back and said, you need to look at this again because there's not a clear question of whether or not the National Labor Relations Act gives the National Labor Relations Board preemption or jurisdiction over cases like this when intentional property damage is involved. And so if the Supreme Court would have held the Washington Supreme Court decision in this case, it would have meant that union officials would have been exempt from tort litigation in the state when it comes to intentional property damage. So there's a little bit more to go in the case. The National Labor Relations Board actually has a hearing coming up very shortly about the other issues in the case, unfair labor practice charges. But yeah, Ketanji Brown was really off the reservation. She says that the Supreme Court has no business getting involved in this if the NLRB expresses even a simple interest in the case and basically has jurisdiction over all these matters. And the court, any court action that at the state level should be frozen and should be preempted by federal law. That landscape for unions would have been another dramatic privilege, unfortunately, for workers and everyone else involved that would be covered by these type of tort actions.
I know before in some of her confirmation hearings, it came up that she went quite light on pedophiles, those with child pornography found on their computer. So I guess it's not the largest jump in the world at property destruction. What's the big deal with that too? So unfortunately, we see what's happening there. But Mark, your foundation put an amicus brief filing in as well on this case. Do you think that helped to perhaps have 8 of the 9 justices, give us the precedent that they have with this?
Yeah, we saw Justice Alito kind of mimic some of the language that we put in our amicus brief because our argument was this is an extraordinary new privilege for organized labor if you uphold what Washington State did and said they don't deserve this privilege. And frankly, you ought to go back and look at the privileges like under a 1973 Supreme Court case called Edmonds, where they're exempt from prosecution for extortionate, violent activity if their objective is a legitimate union objective. I mean, no one else gets that type of privilege. And then when you think of the underlying core privilege that union has to force workers to pay union dues or fees in order to keep a job and then force them to associate with someone they don't want to, those are extraordinary. And this would have added just another layer of that privilege cake that union officials have enjoyed for many, many years, frankly, too many years.
Mark, congrats on the outcome of this. And like you said, I know there's still some more issues that need to be ironed out, but we're happy with the precedent, the victory that has been set here. Thanks so much for joining us tonight.
My pleasure, Kara. Thank you.